Title slide, Intellectual Property. April 27, 2021. An image of two women hunched over laptops on a small table between them.
I'd like to welcome you to the NIA and NHLBI Entrepreneurship Workshop Series on Intellectual Property. Our featured speakers are Dr. Don Rose, who is the Entrepreneur in Residence at the National Institute on Aging, National Institute of Health. We also have John Darling, JD, in-house counsel at Smart Patent Law Group. And we're joined by Gautam Prakash. Dr. Prakash is the Intellectual Property Advisor at the National Heart, Lung, and Blood Institute at NIH. And I'm Monique Laroque, your moderator. Today, you'll hear an overview on intellectual property.
Slide, workshop format.
A good portion of our time will be focused on those breakout rooms. We'll be featuring our moderated Q&A with panelists. We'll have 3 breakout rooms today: elements of a patent application process, and working with university-owned IP. You can see each of the key experts in those breakout rooms. And I also just want to let you know that we have the ability to push you into the room that you pre-signed up for. However, if you change your mind, you can work with us and we can try to assign you to a different room.
About the entrepreneurship series.
We hope you enjoy this entrepreneurship series. It is part of a group of presentations we put together, hosted by NIA as well as NHLBI. Our goal is to really offer research entrepreneurs and biotech small business owners, giving you key guidance to help and support your commercialization and startup. These sessions are taking place this year and some early into next year, and we'll be covering a lot of entrepreneurship topics and really focusing on our current awardees to help them apply it to their efforts. We do have some of these workshops archived, and we will archive this one today. If you go to the NIA Office of Small Business Research website, you can find it there under archived events. And for those who are awardees of NIA and NHLBI, we're also offering more in-depth one-on-one conversations, and we'll talk a bit more about that later.
Entrepreneur Workshop Series, upcoming events.
These are a few of the workshop sessions that we have coming up. We encourage you to register today for the licensing and partnering agreements. That's going to be June 22nd. You can actually go in and do that during this meeting while you're listening. The next ones you can see on your screen will be focused on competition differentiation, looking at regulatory strategy, pitching and promoting your company, as well as investment funding. And with that, I would like to welcome Dr. Prakash.
Understanding Intellectual Property, IP.
Hello, thank you, Monique. That was fantastic. So I'm Gautam Prakash, and I want to talk to you first about intellectual property. So intellectual property, specifically intellectual property protections, are really critical for a startup. And this seminar is entitled Understanding Intellectual Property, and there are really 4 major types, as you'll see here. We're really going to spend most of our time on the last one, patents, but copyrights, trademarks, and trade secrets are equally important, and they can serve as additional layers of protection for your intellectual property. And I've seen some questions come in about what you can do with software, and copyrights and trade secrets may be more suitable for software than patents, but patents really are the major, what people generally think about, and they're the most valuable forms of intellectual property because for a startup, often that's all that you have.
Elements of a patent application.
So when we talk about getting a patent application, what we'll see is there are many elements that belong in a patent application. These are the key ones. Almost all of these are actually required. A title is required, an abstract is required. You want to keep them short and sweet. The specification, or we call the detailed description, is the description of your invention. Drawings and figures may or may not be required, and certainly if you're patenting a device, they're very important. Sequence listing if you're doing anything with DNA or proteins, and of course a claim. A patent application has to have a claim. Almost everything else is not as much required. So I'm going to then now turn to my friend and ex-colleague John Darling to talk about elements on how one actually goes to getting a patent application. John is vastly experienced. He's been a patent attorney for big and large firms. and has also worked for large companies, and he will talk to you about the process of obtaining patents.
Patent application process.
Thanks, Gautam. Hello, everybody. Obviously, the patent process starts when you have an invention. Of course, 10 years or so ago, what was an invention was not something we talked about very much. But in the last 10 or 11 years, the Supreme Court has issued some decisions that make it, at least from my perspective as somebody who does patent preparation and prosecution work, it's almost all we talk about now. What is an invention? It's become a very thorny issue in the law, and we're advising clients every day on their disclosures to us, and trying to give them the best advice we can given the shifting landscape. And of course, you know, an invention requires inventors. There's currently debate about who is an inventor. There's a question: can AI applications be an inventor, a non-human inventor? But inventorship in the United States is a very important issue, as our patent system is rooted in the Constitution's grant of authority to Congress to allow authors and inventors exclusive rights to their discoveries and writings. The other big issue that comes up after inventorship is you may have invented it, but do you own it? Ownership is a very important aspect of the patent process. In the United States, there are various laws as to you know, who owns the fruits of an inventor's sort of creativity. Many employees are covered by agreements that require them to assign the ownership of their inventions to their employers. And representation of the owners of intellectual property is also important in the United States, and it's around the world. In the United States, while you're not required to have, you can represent yourself at the patent office. If you choose to use an attorney or an agent to represent you at the patent office, they have to be registered by the Patent and Trademark Office, who have the authority to license attorneys and agents to practice. The patent office is an administrative agency. It has a lot of rules and regulations that are, I wouldn't say they have traps, but it has stumbling blocks that you know, certainly inventors need to be advised of and guided through by someone who's familiar with the process. As we're here in the United States, you know, filing is first done usually by inventors in the United States. We have laws in this country that require you to, if you invented it, if you're a U.S. citizen, to file here first. If not, there are some, well, drastic results if you don't file in the U.S. first. We have laws on you know, export controlled information that require the patent office to review your application or the subject matter of your application before you're allowed to file outside the United States. In the rest of the world, the filing, once you've filed in the U.S., requires strategic thinking as to how you're going to go about obtaining protection for your invention outside the United States. There are quite a few avenues to do that. And while U.S. attorneys are mostly familiar with them, U.S. attorneys and agents are not allowed to represent you in jurisdictions in the rest of the world. And so that's another aspect of the process that you need to navigate, getting representation in jurisdictions outside of the country. An examination is a very nuanced process at the patent office. It's non-adversarial, meaning you're not being opposed by somebody, but the examiner is charged with protecting the public interest and making sure that they don't grant patents on subject matter that's not eligible for patenting, that's not already out there in the prior art, or be obvious from the prior art. It can take months to years, and it's something that I've been doing it for May 3rd will be my 22nd year in practice, and I'm still learning new things every day. So it's never mastered. It's always practiced. And of course, once you get a patent, that ends the patent process, so to speak, but it just begins the process of your post patenting journey. And the patent office has there was a law passed in 2011. It took effect in 2013. That's provided a whole range of options for people to oppose your patent once it's granted to you. There's also post patent strategies to maintain your invention. You can file continuations, divisionals, and other procedures at the patent office that allow you to perfect or seek broader coverage of what you were initially given. And those are all procedures that require, again, a lot of guidance from people who are determined by the patent office to be competent to practice before the agency. So, and I'll throw it over to Don now. He's going to talk about licensing.
Licensing university-owned intellectual property. Don Rose.
Thanks, John, and welcome everyone to this workshop. Excited to have you here. I'm going to kind of round out the discussion with some of the aspects of licensing intellectual property. My remarks are going to be primarily focused on university-owned intellectual property. It turns out that a majority, I would say, of startup companies derive their intellectual property from a university invention. And this intellectual property that comes from university can be a wide variety of assets, if you will, or forms. Certainly issued patents that have already been issued that have already been gone through this process that John outlined earlier. Patent applications. Gautam talked about the different aspects of a patent application that can be licensed, or that's part of this intellectual property package. It could be disclosed inventions, so things that have not even been applied for as a patent can be part of this, can be defined as intellectual property. Universities also have know-how. That's a harder thing to license, perhaps, in terms of intellectual property, but it is something that is still within a university. And then finally, tangible assets are the kind of those are typically things like mice, or and that licensing involves typically an MTA, something of that nature. So let's talk about who owns the intellectual property, and if it's university owned, why, and what does that mean? I won't go into all the details of the Bayh-Dole Act that was passed in 1980, I believe. And basically what it said is that if the federal government funds research at a university or other research institution, then any inventions that come out of that research are owned by the federal government, but are assigned to and title is given to the university for commercialization, for translation and further commercialization of that invention. But in taking title, the university is required to do a number of things: filing patents. There are these mark-in rights, which people get really upset about, which aren't as onerous as they sound. And they have to share royalties with inventors as part of that. We can also talk about university may not own all of the IP, and maybe jointly owned between a company and the university. And that creates a bit of a wrinkle. And then one last thing to consider in kind of university-owned IP is faculty consulting can generate IP through that consulting agreement. And so that has to be accounted for somehow. And every university has a different approach to that faculty consulting agreement and who owns the IP that could come out of that consulting. And finally, we'll talk about licensing and some of the aspects, some of the terms that are in the license agreement. And then also talk about some of the tips and trying to negotiate a license with the university. I spent 10 years at University of North Carolina helping companies spin out. And so I've seen both sides of the equation, both from the TTO office perspective, but also from the startup perspective. And you need to understand to a certain extent how these knobs are connected. When I say knobs, you've got, say, one term here like equity and another term here like royalty. And if you turn one knob, it can affect the other knob in terms of how the negotiation process goes. So you need to understand a bit how these controls are connected to a certain extent. And finally, I think people forget about post-transaction. Once you get a license agreement signed, there's a lot that has to happen after that in terms of communication. And then, as they always say, the best time to renegotiate an agreement is right after you signed it. And so there's lots of renegotiation that happens after signing it. So those are the kinds of things that we'll touch upon. We have a list of questions. The only thing I will say is that the next workshop is going to talk about transactions in a lot more detail. In fact, here's the slide. We're going to, the next workshop, which you can sign up for today, is going to be on licensing and partnering agreements. And we will cover specifically in more detail the university license agreements. But now I'm going to turn it over to Monique and we'll get rolling.
Connect with NIA, nia.nih.gov/SBIR, on Twitter, at NIA_SBIR, on LinkedIn, NIA Office for Small Business Research. Email, niasmallbusiness@mail.nih.gov. Embedded links to upcoming events, funding opportunities, and mailing list.
Thank you. So now we'll be getting into the fun part, but before we do that, I just want to make sure you have every point of contact for us so that we can stay connected and help you be successful. Here you'll have our website. You can see we're encouraging you to please follow us on Twitter and LinkedIn today. And then we have a variety of upcoming events and funding opportunities we want to make sure that you're aware of. And please feel free to email us with any questions you may have if you think of something after this meeting that you forgot to ask. We have the same information for NHLBI. You can see their site, their social platforms, and email as well. And we've put those for you in chat.
Post-breakout, one-on-one meetings.
So I did mention earlier that we will have these breakouts, but if you decide that you are an awardee and you would like to have additional coaching, if you are part of NHLBI or NIA's awardee, SBIR awardees, then we can set up a time to meet with you. So please feel free to email nia smallbusiness@mail.nih.gov. You can also email NHLBI_SBIR@mail.nih.gov. Again, we wanted to thank you for joining us, and please feel free to fill out that feedback form. We're trying to get 100% participation if possible. And with that, we'll be moving over to the breakout rooms.
Please share your feedback at bit.ly/3sv, uppercase B, 5, uppercase FR.